Welcome to the webinar. I'm Ingrid Brunk, Professor of Law at Vanderbilt Law School. Along with Monica Hakimi, I serve as the Editor-in-Chief of the American Journal of International Law. The journal has hosted a series of webinars covering a variety of subjects. You can find them on the AJIL website. Click on the AJIL webinars tab. Today, as you know, we're discussing the war between Hamas and Israel. We do so with heavy hearts. We do so with great urgency. We do so with sadness. We do so with outrage at the incredible and unthinkable harms inflicted on so many thousands, even millions of people. We also do so with a profound concern for our field, for international law, with many questions about what law can offer here in the midst of crisis, in the midst of profound moral issues that sometimes don't seem fully captured by legal norms themselves. So that's the subject of the webinar. We'll talk about the conflict itself, the use of force, and then we'll talk a little bit more broadly about law in general and the responsibility of international lawyers. We have four incredible panelists who I imagine are all known to the audience, and I will introduce them in a way that doesn't do justice to their incredible CVs, but I want to be able to take the time to turn to the issues at hand. We have Alejandro Chehtman, Professor of Law at the University Torcuato de Tella in Buenos Aires, Argentina. We have Janina Dill, the Dame Louise Richardson Chair in Global Security at the Blavatnik School of Government at the University of Oxford. We have Adil Haque, the Professor of Law and John O. Newman Scholar at Rutgers Law School. And we also have Steve Ratner, the Bruno Simma Collegiate Professor of Law at Michigan Law School. All right, so with those introductions in place, let's jump in. Steve, could you begin by setting out the international legal frameworks governing armed conflict and the use of force?
Sure, be happy to, Ingrid, and thanks for having me today, and welcome to our audience. International law basically has two different sets of rules and norms when it comes to the use of force. One, the law on the recourse to force, in Latin, the jus ad bellum, and one on the law on the conduct of a war or the conduct of hostilities, the jus in bello. This idea of having two bodies of law is basically based on a sort of fundamental moral position that the ends do not justify the means. So we have a set of rules about why states can go to war, and we look at those and decide whether a war is justifiable, whether it's aggression or whether it's self-defense. But the answer to that question does not affect our evaluation as to whether the war itself is being carried out in a lawful or unlawful way. And so it's important to sort of start with what's called that separation thesis. There are some moral philosophers who've been pushing against that idea, saying that the rules on the use of force during a war should reflect the justice of one's cause. I think this war is a good example of why that is a path to be avoided. On the side regarding the recourse to force, the jus ad bellum, there are a variety of ways of interpreting the recent events. It could be seen as an armed attack by Hamas, leading to recourse to self-defense by Israel under Article 51 of the UN Charter. It could be seen as an ongoing armed conflict between a non-state actor, Hamas, and a state, Israel. It could be seen as a permissible resistance by a people of an occupied territory to occupation, and a permissible response by the occupying power. However one looks at it from the perspective of the jus ad bellum, however, we still have these rules on the jus in bello. And on that, we also have, in a sense, two sets of rules on interstate conflicts, so-called international armed conflicts, and rules on non-international armed conflicts, rules that cover conflicts between states and non-state armed groups or among non-state armed groups. The current conflict is difficult to put into a neat box. There are a number of ways one could look at it. One might see it as an international armed conflict if one sees Palestine as a state, although some rules regarding international armed conflict, like those concerning occupation, apply even if Palestine is not a state. One could see it as a non-international armed conflict between a state and a non-state armed group. Fundamentally, though, those distinctions don't matter for the most part because the rules concerning the protection of civilians in the course of hostilities are not fundamentally different depending on this sort of classification. And I think it's kind of a sideshow to spend too much time on it, although it will, as we will probably discuss later, have some implications with respect to criminal responsibility. The only other point I just want to make is a very, very important one regarding countermeasures and reprisals. The law of international humanitarian law's rules on the protection of civilians are special in the field of international law because they are rules in which the violation by one side does not permit the other side to suspend its obligations. So there are no countermeasures that are permissible. So just to be very blunt about it in terms of examples, the illegality of Israeli settlements in the West Bank under AJIL, which is pretty much accepted by all international lawyers, does not offer a legal justification for indiscriminate attacks on civilians coming from Hamas. And similarly, the taking of hostages by Hamas would not justify disproportionate force by Israel. We simply don't talk in those terms when it comes to the protection of civilians.
Thank you, Steve. You've answered already some of the questions that we've had posed to us through the email, but I'd like to flag a couple of issues that our listeners would like to see addressed. One, you mentioned this, but if you could say a little bit more about the connection between occupation and the description of this conflict as an international armed conflict or a non-international armed conflict. In particular, does occupation always lead to an international armed conflict? Is it possible that we can have a system place where these two forms of conflict coexist?
So this case is again one that tests the boundaries of the categories, and again, you know, is a large question about whether one believes in categories. There is, of course, this classic way of understanding IHL with two sets of armed conflicts. The rules regarding occupied territory appear in the Fourth Geneva Convention, which is a convention on international armed conflicts. However, it's long been understood that even though, regardless of whether or not Palestine is a state, and long before it was accepted as a statehood, it's been long understood that Israel has duties as an occupying power. Now, that raises an additional question about whether, in fact, Israel continues to occupy Gaza. There are disagreements of opinion about that. There are some who say that because Israel doesn't have effective control on the ground because of the power of Hamas, that Israel's not an occupying power. There are those who point out that because Israel has control over the land, sea, and air borders and has the potential, potentially to control parts of Gaza, that it is an occupying power. The ICRC takes the latter view. And regardless of whether or not Israel is an occupying power, one can still have these rules that treat Hamas as a non-state armed group that is governed by the rules of the NIAC. So in a sense, I guess what I'm saying is, yes, one can sort of see this as a situation where both sets of rules apply, and yet the overlap between them when it comes to the protection of civilians is so significant that I really don't think we should make too much of it.
All right. Excellent. So with that sort of general framing of the international legal issues in place, let's talk a little bit more about the specifics of the current conflict. And let's turn first to Hamas's initial attack on Israel and the subsequent actions of Hamas. So Alejandro, how do you see the legal issues, especially the jus in bello issues, raised by Hamas's actions?
Thank you, Ingrid, and thank you for everyone for joining. This is such a difficult time to be talking about this issue, so I'll try to be as careful and as precise as possible. I think the best way to tackle this question is to clarify a few fundamental points. The first one is that intentional killing of civilians is a violation of international humanitarian law and a war crime. Can be a willful killing as a great breach of the Geneva Conventions, intentional targeting of civilians as a serious war crime, or murder in terms of Common Article 3, depending on whether you classify, as Dill was mentioning, this as an international or a non-international armed conflict. Now, two clarifications that might be useful for non-specialists. First, war crimes are a subset of particularly serious violations of the jus in bello or international humanitarian law that particularly entail individual criminal responsibility. This means that a particular action might violate both the rules, the laws of war and international criminal law, insofar all war crimes also involve necessarily a violation of international humanitarian law, even though not all violations of international humanitarian law are war crimes. And secondly, when we talk about intentional killing of civilians, civilians do not only include children, women, the elderly, but also individuals with different beliefs, political supporters, and even reservists not engaged in active duty and security forces not engaged in the hostilities. So the intentional killing of civilians, I think, has been widespread and quite clear in the attacks. The second element is that taking of hostages is also forbidden at all times during armed conflict, and it also constitutes a grave breach to the Geneva Conventions and a serious violation to Common Article 3. So it's also a war crime both in international and non-international armed conflicts. And third, using weapons that do not distinguish between military and civilian targets, such as launching rockets, which are aimed at densely populated areas, again constitutes an indiscriminate attack, and it's both a violation of international humanitarian law and war crimes. And also using human shields is a war crime. And this is one of the few areas in which I think it might be important to the classification of armed conflict, because using human shields is clearly a war crime under international armed conflict, but it's not necessarily, or at least not uncontroversially, a war crime in non-international armed conflicts. Now, one final clarification on this particular violation of using human shields. The fact that human shields is prohibited and, in fact, criminalized under international law does not have any impact on the prohibition of directly targeting those shields, or in targeting or being considered them as a target which disproportionately causes harm to these civilians. So the fact that they are there, it's also a limitation for those using force against Hamas in this particular case. Now, I've mentioned that all these four categories of acts constitute war crimes, and I'm sure they, at least most of them, could be also qualified or considered crimes against humanity. And I'm not using a particular category that might be expected in this context, which is terrorism, although most of these attacks would constitute terrorist attacks under any relevant approach. I don't think that that's the most important or relevant or useful approach. I think we may more strongly condemn these acts as crimes against humanity and war crimes, and that these categories provide us with better institutional and legal mechanisms to fight for accountability and reparations.
Thank you. As with respect to a fair amount of the conduct that you've described, I don't see in the conflict a lot of disagreement about facts on the ground, right? There are hostages, right? And I don't see much actually disagreement about the law in significant ways. But I wanted, maybe you could help clarify for me and for our listeners a little bit more about human shields and how that works in a really densely populated area. So what conduct by Hamas, it's almost, as everyone knows, it's almost impossible for Hamas to do anything that doesn't involve close proximity to civilians. So what is the legal threshold for that constitutes using human shields and makes it the conduct of war crime?
So essentially, to put it very basically, it's intentional using human shields. So using schools and hospitals and places of worship as places to store equipment or arms or weapons or even to militants, that would be clearly a form of prohibited and criminalized use of human shields. Now, on the other hand, on the targeting issue, I think that international law there is much more limited in the sense that it's very difficult to determine when harm to those human shields is prohibited under international law because the principle of proportionality, which is the one that would, I mean, except when it is intentional, of course, but when it's not intentional, which is a form of incidental or collateral harm, the principle of proportionality does not provide us with strong considerations to easily criticize or condemn certain acts that will, of course, harm these human shields disproportionately.
Terrific. Thank you. So we'll turn to the IDF now, but let me just ask, Adil, do you have any comments or thoughts on this aspect of what we're talking about?
Just two things. As Alejandro said, the crucial element of use of human shields is intent. And so it's the intent to use the presence or movement of civilians to discourage, dissuade, or impede attacks on those using the human shields by the opposing party. So as you pointed out, there is another set of rules that says that fighters should, to the greatest extent feasible, separate themselves from civilians. But as you pointed out, in some densely populated areas, it may be impossible to do so completely. The categorical prohibition is on the intentional use of human shields, the intentional use of civilians to discourage attacks. So it's not just a coincidence that you happen to be in a civilian building or near civilians. You're using their presence to discourage attacks on you. And so it's really that element of intent that violates the categorical prohibition.
Terrific. Thank you. Janina, let's turn to you now and think about the conduct of the IDF. I want to just broadly, at least initially, think about this in two buckets of issues. Let's put to one side right now the siege and the questions of access to Gaza, and just focus on airstrikes and other conduct other than the siege. Take it away.
Right. Maybe I can start by saying that some violations of international humanitarian law and even war crimes are relatively straightforward to diagnose. So what Alejandro talked about, when Hamas goes into the home of a civilian, kills them at close range without any direct connection to a military operation, we can be relatively confident that this is not only a violation of international humanitarian law, but a war crime. Now, some violations and some repertoires of violence are much, much harder to diagnose, particularly from afar. So let me start by giving some facts of the IDF air campaign so far. So UNOCHA reports that as of yesterday, 3,700 Palestinians in Gaza have been killed, including at least 1,500 children whose civilian status is beyond doubt. Around 12,000 have been injured and more than 500,000 internally displaced. When it comes to structures, around 25 to 30% of your housing units are destroyed or damaged. And the IDF has dropped well over 6,000 bombs on an area that's about twice the size of Washington, D.C. in about less than 2 weeks. To the best of my knowledge, these facts aren't contested. Neither is the sort of unimaginable humanitarian catastrophe they imply. These actions by themselves, though, are not conclusive evidence for non-compliance with the laws of armed conflict. That may be somewhat hard to stomach for some of our listeners, but actions that result in dead, starved, or displaced civilians may well be compatible with international humanitarian law. Now, what AJIL does prohibit, and we've already talked about this, is intentionally attacking civilians. And for the purpose of criminal law, that includes willful, so reckless attacks against civilians. And it prohibits unintentional civilian harm that is excessive to the military advantage an attack reasonably promised, so the principle of proportionality. So if we start with distinction, then we have to ask what the intent behind some of these IDF airstrikes is. The legal relevance of intent is why statements of Israel's senior political and military leadership have evidentiary value for our diagnosis. And these statements are profoundly worrying, right? Since the beginning of the conflict, this has been widely reported. There have been public declarations that have failed to differentiate between Palestinians and Hamas. There have been suggestions that Palestinians are responsible for the terrorist attacks, the atrocities really that Hamas has committed. And there have been reports that the notion of statements like the point here is damage rather than precision. So this wouldn't be enough evidence, right, in a criminal trial of individuals involved here, to say that this is actually a violation or even criminal. But it has been enough for several credible organizations, some with presence on the ground, like Médecins Sans Frontières, Civic, or UN experts, to allege violations of the principle of distinction. To me, it's really important to combine this fact pattern with the tone set by military and political leadership, right? So if we think of what does it mean to willfully attack civilians, we can think of this in terms of a type of recklessness where you don't necessarily have the desire or purpose, or you welcome civilian death, but you reconcile yourself with the notion that it's definitely going to happen, right? Now imagine an IDF soldier sent into this context, right? Against the backdrop of the statement from political leadership, which suggests that maybe Palestinians aren't actually entitled to, maybe they don't deserve the full protection of civilians. I think it makes it much easier for IDF soldiers to then reconcile yourself with the harm that certain patterns of violence will cause. And that's profoundly worrying. So to be clear, it's not possible to diagnose for sure from afar that there are violations of distinctions or even war crimes. But I think there's enough evidence here to warrant an independent investigation. Quite a few of our colleagues, I think, give Israel the benefit of the doubt and say that some or all of the civilian harm that's been caused isn't intentional or even reckless, which would then mean we have to turn towards proportionality, right? And unfortunately, proportionality or violations of the principle of proportionality are even harder to diagnose from afar, because what we would then have to ask is what an individual airstrike, so proportionality doesn't attach to the aggregate numbers I gave you at the beginning, right? The overall civilian casualty count. But we would have to ask about individual attacks, individual airstrikes, and ask here, what was the reasonably foreseeable civilian harm and the reasonably desired or anticipated military advantage? And we need much, much more facts. Law is really fact hungry here than we currently have to say that about individual airstrikes, right? I would like to make three very quick points before I wrap this up. One is to say it's actually relevant that this isn't the first air campaign that Israel has waged against Gaza for the purpose both of proportionality and distinction, particularly for proportionality, right? We're asking here about reasonableness, right? Particular types of airstrike. What is a reasonable expectation of collateral damage? What is a reasonable expectation of military advantage? It's doubtlessly true that there are militarily valuable targets here and that Israel has a lot to gain in terms of military advantage, degrading Hamas capabilities. But it's also important that on previous air campaigns, some learning should have taken place, right? So for instance, for the Operation Protective Edge in 2015, OCHA then reported that 67% of the casualties in Gaza were actually civilians and 35% of them children, right? Which suggests that the reasonable observer should expect some of the civilian misery that we have been seeing. And the two other points just relate to the notion that we've briefly already touched on, the idea that human shields don't actually lessen the obligations on the IDF here. A human shield remains a civilian for the purpose of civilian, particularly involuntary human shields do not directly participate in hostilities. But the other point I wanted to make is that the warnings the IDF sometimes issues and even evacuation orders, they also don't actually lessen the protection that Palestinian civilians are afforded, right? So a civilian that doesn't heed a warning, that doesn't evacuate, remains a civilian for the purpose of international law, right? They don't count less in the proportionality calculation, and they definitely don't lose their protection from intentional attacks. So with all these things in mind, I think the bottom line is that there's a lot of concern here, the reason for concern, particularly if we combine the facts that we do have with a sort of tone set by the statements that have been reported, but also that we need more granular facts, more granular evidence to say something more specific about violations and particularly about war crimes.
Thank you for putting this in the context of other IDF airstrikes. I think that's really helpful. And I'm curious, when you talk about the language used by political leaders, whether you see a change. And I think, you know, the IDF, you know, describes itself and prides itself on its adherence, generally speaking, historically, to the principles of distinction and proportionality. Do you see a change, right? Has the language shifted? Is something new happening here?
So the sort of message discipline that we are used to from the IDF and previous campaigns, which is very much, you know, we don't only meet the demands of international law, we exceed them, right? That is a point that is notably muted now. We hear that much less. What particularly worries me, which is this sort of a new discourse, is that some voices I associate with commitment to international law suggest that what is different now is that Israel is struggling for its survival, that the threat from Hamas has now proven to be existential, and that may mean that the role that international law has and its implications must be reevaluated. There's certainly a tradition in jurisprudence which suggests that when the life of the nation is threatened, no legal shackles can wisely be imposed on those to whom the care of the nation is committed, right? But I think this is a profound mistake in this context. And it's a mistake partly for what Stephen earlier mentioned, right? International law sometimes looks morally quite defective to us because it brackets all kinds of questions we want to ask to figure out what is morally permissible violence, right? So who started it, who's worse, who has a morally important aim? But in this conflict in particular, right, where you can reasonably say both sides have some morally important aims, right? Being thrown back to our moral judgments is very unlikely to make things less bad, to lead to restraint. So what seems like international law's sort of moral defectiveness is in fact its greatest asset here, which is that it provides bottom lines that are applicable and action guiding, even if you disagree about the fundamental moral questions that underlie it, right? So I think the relative abandonment of international law in words and possibly in deeds that we see on the part of the IDF, if we compare it to its previous conduct, is very, very worrisome, because I think in this conflict in particular, international law is our best hope for restraint.
Steve, do you have anything you want to add here?
Just a couple of brief points, but very much along the same lines as what Janina said. I mean, I think the larger question about the sort of factually clear situations and factually disputed situations raises just a huge challenge for implementation of IHL and even accountability after the facts, even after supposedly everybody's had a time to sort of look at what's happened. I mean, we have this dilemma for outsiders who are not absolutely committed that one side is completely right all the time and the other side is completely wrong all the time. If you're open-minded to facts changing your mind, you have this dilemma of not wanting to prejudge, let's say, certain Israeli actions in Gaza, but then at the same time, we have this as international lawyers, this desire to see the rules actually followed. And so, you know, sometimes with with cases that are not absolutely clear on the facts, we still feel like we need to make judgments. So we have some, you know, some of the very clear ones that Janina mentioned about direct killing of civilians and taking of hostages. And then we have these others. So I think that is a big challenge. And even after the fact, I mean, after the Gaza war of 2009, the UN had a commission of inquiry, the Goldstone Commission, the Israelis wrote up their own thing, and they still disagreed about whether the attacks were proportionate. And the Israelis did this whole study after the 2014 war where they justified a lot of what they did. So even after the fact, there's still going to be these arguments about what's proportional because of the inherent incommensurability of the two values on the side of the proportionality calculus.
All right, let's turn now to the siege on Gaza and the order or the suggestion that civilians leave part of Gaza, and whether that's on the one hand possibly a forced displacement of civilian populations, or on the other hand, is that a lawful and helpful suggestion to evacuate and a warning of what is to come. Adil, can you move us forward on these questions?
Sure, happy to. So first, Israel has prevented humanitarian relief from entering Gaza, not only from Israel, but also from Egypt, including by bombing the Rafah crossing. So this violates international law, according to which the parties to the conflict must allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need. If, like the ICRC, you accept that Israel remains the occupying power in Gaza due to its continuous control over Gaza's borders and essential services, then Israel is also violating its positive or affirmative duty of ensuring the food and medical supplies of the population. So there's a kind of double illegality there. Second, Israel has also cut off water, fuel, and electricity to Gaza. So again, if Israel remains an occupying power, then this would breach its affirmative duty to provide supplies essential to the survival of the civilian population. If this deprivation continues, it may lead to the starvation of civilians, which is both illegal and criminal. As the ICRC observed years ago, starvation can also result from an omission. To deliberately decide not to take measures to supply the population with objects indispensable for its survival, in a way, would become a method of combat by default and would be prohibited. Similarly, cutting off fuel and electricity may render useless objects indispensable to the survival of the civilian population. Ambulances and rescue vehicles need fuel. Hospitals and sanitation facilities need electricity. And since Israel is intentionally cutting off water, fuel, and electricity as a method of warfare, this conduct will be illegal if it in fact starves the civilian population. The IDF knows that it does, and it intentionally does it anyway. There's a lot more to say about this topic, but I'll simply refer viewers to the work of Tom Dannenbaum, including a recent post on the Just Security blog. As for the IDF's directive that 1 million civilians leave North Gaza and move to South Gaza, this constitutes illegal forced displacement, not lawful advance warning, as some have argued. So ordering the displacement of a civilian population is illegal unless first it is justified by the security of the civilians involved or by imperative military reasons. And second, all possible measures are taken to ensure that the civilians will have food, water, medicine, shelter, and other essentials when they arrive. In this case, Israel is depriving the civilians of such essentials, so the displacement is illegal on that basis alone. This deprivation also belies any claim that the displacement is motivated by the security of the civilians involved. Clearly, Israel is not overly concerned with the situation that civilians are pressed into. Finally, displacement cannot be justified by military reasons if it leads to avoidable suffering and death. Military necessity does not justify anything, particularly not unnecessary harm to civilians. There's also a deeper point here, which was made yesterday by Yusuf Saeed Khan on the Just Security blog. The ICTY, the International Criminal Tribunal for the former Yugoslavia, has held that displacement is not justifiable where the humanitarian crisis that caused the displacement is itself the result of the accused's own unlawful activity. In other words, the IDF can't displace civilians and say it's for their safety when the IDF is the one endangering them with its own unlawful conduct. So if, as I believe, the IDF is carrying out indiscriminate attacks in North Gaza, it cannot invoke those unlawful attacks to justify displacing civilians to South Gaza. Now, as it turns out, the IDF appears to be carrying out indiscriminate attacks in South Gaza as well, so the point is a bit moot. Now, as you mentioned, it has been argued that the IDF directive to leave North Gaza was an effective advance warning of planned military operations that may affect the civilian population, which is not only permitted by IHL, but in fact required if the circumstances permit. There are several problems with this argument, but I'll focus on one. IHL requires warning civilians of otherwise lawful attacks that may nevertheless endanger them. Informing civilians of unlawful attacks is not a warning. That is a threat. For that reason, the classification of the IDF's directive to leave North Gaza as a lawful warning, as opposed to an unlawful threat, depends on the lawfulness of the IDF's bombing campaign. Now, as Janina and Steve mentioned, many of our friends and colleagues would say that we can't know whether the IDF's bombing campaign is lawful or unlawful. We would need more information about what the IDF is targeting and why, what precautions they could have taken but didn't, how much harm they expected to inflict on civilians, and why they bombed anyway. And I understand this point of view. We are scholars, after all, and we have the luxury of time. But people on the ground in Gaza do not have any luxuries anymore, and they are running out of time. And it is clear how they view the IDF's directive. Every NGO on the ground, every UN agency responding to calls from the field, the Palestinian Red Cross, and the ICRC itself, they all say the same thing. Rescind the order, stop bombing ambulances. Rescind the order, stop bombing hospitals. Rescind the order, stop indiscriminate attacks. Rescind the order, follow IHL. So they see the IDF's directive not as a warning, but as a threat. Maybe they are wrong to do so, but by the time we as scholars feel ready to make a definitive judgment, it will be too late for them.
Hey, thank you. Janina, do you have anything you want to add here?
I certainly don't have anything to add to Adil's legal analysis of this. One point about sort of our scholarly discourse around this. One issue when the judgment or the classification of an action hinges on intent, right? That's in some sense, if you judge it from afar, an invitation for your confirmation bias to take over the argument, right? Because someone who gives Israel the benefit of the doubt sees a warning where someone who is, entrenched with the misery of the Palestinians will see a threat. Someone, who thinks the IDF is the most moral army in the world will think of this as a legitimate military siege, whereas someone who is on the ground and sees the suffering that it causes will see the intentional use of starvation as a method of war. There isn't a particularly easy solution to this, but I think what Adil is saying that is critically important is that we sometimes have to deprioritize the judgment that we make from afar in favor of taking the word of the people who are on the ground, who really see what is going on. That is why I sometimes think that even if we as scholars, and if the lawyer in you says, well, there isn't enough evidence, I can't make a complete judgment here, that it matters critically what the people say who see this directly from on the ground. That's the only thing I wanted to
add. Thank you. Let's shift gears just a little bit. There are so many bodies of international law that are potentially implicated here. We haven't talked yet about human rights. We certainly don't have time to do an in-depth deep dive here, but Alejandro, I just wanted to ask you, are human rights even relevant in a situation of either non-international, international armed conflict? What work might human rights do here?
Thanks. Yeah, I'm gonna keep it short. I think indeed we now take as an uncontroversial legal statement that international human rights law is not displaced by the application of international humanitarian law, even though it might affect the way in which they apply in a particular case. And this has important implications for, it forces us to never lose sight of victims, including, for instance, people suffering in Gaza and also the devastating situation of hostages. Secondly, international human rights law allows us to insist on the critically important point that the rights of every person involved in this situation is protected. One would think that should not be clarified by now, but it seems, given the current context of public debate, that is worth restating. Third, I think international human rights law allows us to broaden a little bit the lens and also take into consideration the pre-existing context that in which this conflict is set, and also the future legal responses, and this includes sensitive legal and political questions such as the right to self-determination, basic human right to food, but also the rights of victims to truth, justice, and reparations. And finally, I think international human rights law is an important aspect of the discussion that we should not lose sight of it in the context, because it allows us to institutionally bring in UN human rights bodies and mechanisms, and it provides us with a useful language to intervene in fora such as the UN Security Council and the UN General Assembly. So yes, human rights law, international human rights law is still applicable, and it has a role to play in the current situation.
Excellent. When we, we've described on both sides a lot of conduct around which there's great consensus that international legal norms have been violated, and more specifically, international criminal law. So what about, very briefly, methods of accountability? Obviously, the International Criminal Court is cited very frequently in this context. We also might have universal jurisdiction. How far do you think these methods will get us? And the narrow question is, what is the jurisdiction of the ICC? But you can take the question as broadly or narrowly as you want. Adil, maybe you could start us off.
Sure, happy to do so. So the ICC has jurisdiction over international crimes committed in Palestine or by Palestinians, so on the territory of Palestine or by its nationals. So this would include crimes committed by the IDF in Gaza and also crimes committed by Hamas in Israel. The prosecutor, Karim Khan, over the last week or so has given some interviews indicating that he is reminding everyone that the investigation is ongoing, and the office has in fact solicited additional information. Whether the prosecutor is willing to devote personnel and resources to address the current bloodshed remains to be seen. His statement was not the strong "we are watching you" type of statement that I would have liked to have seen, but it was at least some reminder that the court is engaged, or the prosecutor's office is engaged with these issues. And I'll let Alejandro address the question of universal jurisdiction if he wants, since that is his forte.
Yeah, terrific.
Thank you. Yes, also I agree totally with Adil's legal analysis of the ICC, and universal jurisdiction would be relevant for these offenses. There is currently conventional universal jurisdiction under the 4 Geneva Conventions for grave breaches under the conventions, which is specifically serious war crimes, and that creates us the duty on states to criminalize those war crimes and to either prosecute or extradite those war criminals who are found on their territory. But importantly, I think there is also universal jurisdiction for other war crimes and for crimes against humanity, such as the one that are quite likely being committed in this conflict. Problem with universal jurisdiction in this context is not the legal basis for it, but rather how it will work in practice, whether states will be able to get a hold of suspects and whether it will be able to conduct delicate and appropriate investigations on the underlying crimes.
All right, thanks. Before we shift
Can I
gears,
just add one more thing about the accountability, which is, of course, there are ways of holding people accountable without going through the International Criminal Court or universal jurisdiction, and that's through sanctions, targeted sanctions by the UN, by individual states to prevent travel, to freeze assets. This is far more likely to happen than any kind of criminal proceedings in the short term.
Could I also add one point on accountability? We focus a lot on individual accountability, particularly criminal accountability, but the powerful actors here are states. And one of the truly troubling features of this particular round of the conflict is the complete moral and legal failure of third states to do what they can to lessen the suffering here, right? There's no notion that the British government or the German government or the Americans or even Iran can just solve this crisis, or Egypt, right? But third states basically so far have done absolutely nothing to make anything less bad, right? They all have some leverage, something that they could do to make it slightly less bad for the civilian population on the ground, to create some kind of accountability for the parties to the conflict's complete failure to adhere to the rules. And yet we have seen nothing of the sort. I'm particularly troubled by the fact that the British, German, and European governments and the American government are even stopping short of calling on Israel to, adhere to its obligations under international humanitarian law out of some, sense of misguided geopolitical coalition. It's important to remind them that they are high contracting parties of the Geneva Conventions, and they have obligations to ensure the respect of these conventions, not just in their own military operations, but also in military operations that they diplomatically and materially support. I think this is relatively low-hanging fruit that could potentially make things a little better, and yet we have seen none of it. So I think, Egypt, the European governments, Iran definitely, and the United States have a lot to answer for it in terms of the lack of accountability.
anyone else before we shift gears slightly?
Maybe just 2 quick points, if I could. So first, the one area where this very kind of technical question of conflict classification is relevant is with respect to the ICC statute, because if the court were to classify the conflict as a non-international conflict between a state, Israel, and a non-state actor, Hamas, several war crimes would not be applicable under the Rome Statute. These include directing attacks against civilian objects, disproportionate attacks, and the use of human shields. So three of the war crimes that really characterize this conflict by Hamas and by the IDF would drop out. So that's actually an area where this seemingly very esoteric distinction might matter. And just the last thing to say is that in one way, the ICC prosecutor has put himself in a good position because he has already put down the marker in the Russia-Ukraine situation that the court can issue arrest warrants for sitting heads of state of non-party states without a Security Council referral. And so if he were to use that precedent here, he would be on very strong legal footing and would put some of his political detractors on the back foot, because of course the United States, the United Kingdom, and others have supported the arrest warrants against Vladimir Putin, and so it would at least make it more difficult for them to attack the prosecutor for doing something similar here.
Terrific. Thank you. When we think about international law and this conflict more broadly, there are so many ways, especially historically, to think about that topic. And maybe one way to approach it is to think a little bit about just the territory of Gaza. What is, and we've mentioned this a little bit, but what is its status in international law, and like how did it come to be separated from Israel and from the occupied West Bank? And then more specifically, what is international law part of this in a good way? That's a really broad and open-ended set of questions. But Steve, I'll let you take those however you want.
Sure. Well, on the narrow question about the status of Gaza, I mean, Gaza was part of the British mandate in Palestine. When the partition plan was designed by the UN in 1947, Gaza was designated to be part of the so-called Arab state. And after the 1948 war, where Israel, after the Arab armies invaded, and Israel ended up being quite a bit larger than the partition plan, Gaza ended up being under Egyptian control, military control, just as the West Bank ended up being under Jordanian military control. It was then seized by Israel in the 1967 war and put under Israeli military occupation. Full Israeli military occupation with troops on the ground, with indeed settlements in Gaza by the Israelis. It was not returned to Egypt as part of the 1979 agreement with Egypt because it wasn't considered part of Egyptian occupied territory, namely the Sinai Peninsula, so it remained with Israel. Israel evacuated the territory in 2005 unilaterally. Hamas took control 2 years later, and we are the existing situation where there are, as we've talked about, disagreements about whether it's still considered occupied. On your broader question, and I'm sure I very much want to hear what the rest of us around the screen have to say. I mean, in a way, international law has played an enormous role in defining standards and framing the debates, sometimes constraining the behavior of parties, sometimes enabling the behavior of parties. We have Resolution 242, which is based on certain international law principles about the use of force and withdrawal of territories, although it doesn't specify withdrawal of all territories. We have the ICJ offering its views about the applicability of international human rights law in the occupied Palestinian territories and the illegality of the settlements. We have international human rights and humanitarian law playing a role in Israeli Supreme Court decisions, either affirming or striking down certain aspects of Israeli conduct, in particular in the West Bank. And all of these conversations many conversations around the world are based in international law. On the other hand, international law can be manipulated. People can use weak arguments if they've already made up their mind. They can convince that they've got the monopoly on wisdom when the facts and the law might be actually very complicated. International law doesn't always dictate one particular outcome to a particular conflict. There are many ways in which the Israelis and the Palestinians may ultimately settle their long-held differences. Many solutions that international law would tolerate. It doesn't demand absolutely one particular border or one particular solution. And so international law, is in a sense limited. One could also be just completely pessimistic and say that this continued conflict shows that international law offers no constraints on behavior, especially when it comes to the use of force. And international lawyers know that the international law and the use of force is in fact the most vulnerable to this criticism. And yet I still believe that as a framework for discussion and as a set of norms that can constrain behavior, it's still a very important part of our way of thinking about this awful conflict.
Thank you. We're moving, unfortunately, to the end of our time. A couple of other ideas that we haven't gotten any traction on, but I think are important, and I just want to put them on the table for folks. Is self-determination, self-determination for whom, and what does that mean? As well as ideas about colonizers and the process of decolonization, what those core international ideas mean in this context as well. We've also touched on the United Nations, both its potential role here and its role historically. I'll note the U.S. Veto of a UN Security Council resolution that would have called for a humanitarian pause is another topic we could have profitably taken up. But I do want to give everyone the chance here at the end. We have 7 minutes left. You're welcome to pick up any one of those balls that I just threw gently in the air, but also to come back to these issues that Steve so eloquently just addressed and that sort of framed us at the beginning, which is, what should we expect of international law in a situation in which there are such widespread violations that are acknowledged by all sides. So with that very open-ended invitation, I'll turn it back to you, Janina.
So international law will always leave us morally unsatisfied, right? It cannot be the be and end all of a conversation about who is right and what should happen. It's not always politically contextual. And as we've already figured out, it doesn't prohibit a lot of things that are morally prohibited. It is a minimum standard, right? We should never use moral arguments to say we can violate the law, but we should certainly say sometimes morality should prohibit us from doing something that is legally permissible, right? International law is disaster relief. It isn't like a moral approach to the conflict. But that is also, in a sense, its strength here, right? Because we cannot agree morally on this conflict. So a lot would be gained if both parties to the war obeyed international law. It sounds naive when you say that about Hamas, it would have a very long way to go towards international law. This is potentially why most of us address our pleas to Israel, because there is a hope that they might, take a step towards international law. I want to make one last point, which is that I sometimes hear people who are directly affected by this conflict, right? That to them, international law, legal arguments ring truly hollow. And I empathize with that. I understand that, partly because international law is somewhat detached from morality. But I want to make the point here that if I put myself in their shoes, what would I do if I were directly affected, if I'd lost a loved one, if I were bereft, right? I wouldn't want law to permit what I would do as a bereaved mother, for instance, right? There's a reason for why legal and moral standards don't cater to that. And what needs to come in then is good political leadership that actually doesn't play to a bereaved, traumatized audience, but political leadership that takes up the truly considered, long developed rules and adheres to them. That takes a lot of political courage, right? Particularly in a democratic context, in a divided society like Israel, but it is absolutely critical. That is the fundamental moment for political leadership, not to play to a traumatized, bereaved audience, to whom a lot of international law must sound absolutely absurd, right? But to actually pick up where international law is truly our best moral hope and try to make a case for compliance. And that's true for the Israeli government as well as the third states that I mentioned earlier. It's even easier for them. They have even less of an excuse not to do it.
Alejandro?
Thanks. Let me briefly add a few things on what Janina was saying. First, I agree with Janina and Stephen that international law provides us a shared language in which we can discuss these issues in a way that we wouldn't be able to discuss morally or politically and find common ground. So first, shared language and common ground. Second, I think international laws we've seen throughout this webinar allows us to identify specific violations by each and every of the actors involved. And that allows us to avoid this kind of comparative pool. I was talking about this in my public international law class, and then I read Janina's beautifully written post. We need to avoid both the moral equivalence of the two belligerents in this conflict, but also the moral question about who is worse or who started it. And I think international law provides us a framework that allows us to identify violations and provide us a framework that allows us to find shared common ground. And finally, I think international law, as the empirical work done by people like James Morrow has shown, diminishes the noise we find and the concerns that many of us shared about how difficult it is to know what the facts on the grounds are. And by providing bright lines about what is permissive and what is prohibited in this kind of conflict, it gives us, again, a basic understanding of how of what the shared ground is. And I think that this basic understanding of the shared ground and the basic rules that apply in this context are a critical first step to de-escalate the conflict, which is something I think we all agree it is terribly needed at the moment.
Thank you both. So to close us out, Adil, I'll turn it to you.
Thanks. So I certainly agree with Janina and Alejandro that there are very good reasons why we're focusing on the rules of AJIL, because as people are being killed, maimed, and displaced, these are the rules that offer the most immediate hope for their protection. At the same time, as international lawyers, I don't think we should be afraid of the broader context in which this bloodshed is taking place. I think that the right of the Palestinian people to self-determination can be affirmed. We can say that Israel is depriving them of self-determination by forcible means. We can even say that the Palestinian people as a whole have a right to resist occupation, while still saying that Hamas is not the representative of the Palestinian people and therefore cannot exercise that right of resistance on behalf of the Palestinian people. And we can say that the right of resistance is the right to use force against the agents of the occupation, of the military and security apparatus of the occupying power. And that therefore the right, it's not that the right of resistance authorizes things and AJIL prohibits them and AJIL wins. It's rather that the right of resistance doesn't extend to attacks on civilians at all. So it's not just that attacks on civilians are prohibited, they're just not an exercise of the right of resistance or the right of self-determination. That's not what those rights are for. And it's a real betrayal, I think, of the third world international lawyers who worked so hard for decades to establish the right of self-determination and the idea of wars of national liberation, to give up on that idea. Their goal was to bring national liberation movements within the international legal framework, to have them assume the obligations under international humanitarian law to respect and protect civilians, not to escape those restraints, not to escape those obligations, but to assume them. Because in assuming them, they not only respect the moral standing of the civilians, they also show that they are themselves states in waiting, that they offer the opportunity for their people to assume statehood and membership in the community of states. Hamas cannot offer that to the Palestinian people, but that is what the Palestinian people deserve, a state of their own. And I think we can acknowledge that while still focusing in the immediate days on protecting as many people and saving as many lives as we can, and focusing on the rules of AJIL for that reason.
That concludes our webinar. I want to just really from the depths of my heart, thank you all for what was a really careful, thoughtful set of interventions in this really difficult topic. So thank you very much, and I look forward to reading all of your work in the various outlets in which it appears. Please keep writing. Please keep commenting on these important events.